UK crypto investors, prepare to have your minds blown because a new law is rewriting the rulebook on digital assets in the UK. Imagine a legal revolution that solidifies your crypto, NFTs, stablecoins, and tokenized real-world assets as bona fide personal property with a clear statutory status. Today, we're diving into what the Property, Digital Assets, etc. Act 2025 means for you, the savvy investor, and how this historic shift could redefine the landscape of wealth management. Let's start by understanding the seismic change this act represents. For years, UK courts have steadily recognized digital assets as property through evolving case law. Face it, courts were already hinting at a transformation. With the new act, that ambiguity vanishes. Now, digital assets officially occupy a legal third category of personal property, distinct from traditional tangible assets and intangible rights. In essence, digital treasures like cryptocurrencies are finally on solid legal ground, providing more certainty for investors and professionals alike. Now picture this: you've invested in Bitcoin, Ethereum, or even that unique NFT that everyone's buzzing about. Until recently, the legal status of these assets was as murky as a foggy London morning. The 2025 Act not only shatters that uncertainty, but also opens up new avenues for asset protection, inheritance planning, and investment strategy. It's a game changer for the financial world and for you. This transformative legislation is breaking new ground by removing long-standing ambiguities. Prior legal opinions often left investors scratching their heads about the precise rights and protections afforded to digital assets. Gone are the days when your portfolio was held hostage by legal uncertainties. Now, with explicit statutory definitions, the Act bolsters your ability to plan, invest, and even pass on digital riches with confidence. Before we dig deeper, let's unpack what these digital assets actually are. At their core, digital assets encompass a wide range of items stored on blockchain technology, from cryptocurrencies that power decentralized finance to non-fungible tokens, NFTs, capturing digital art and collectibles. Stablecoins, pegged to traditional currencies, also fall under this umbrella. Think of digital assets as the modern day equivalent of gold or property, except they reside on a digital ledger that offers new ways of transacting and storing value. Why should you care about the new legal recognition of these assets? First off, it creates a safer environment for investors. By defining digital assets as a distinct type of property, the law clarifies their treatment in scenarios like insolvencies, estate planning, and even dispute resolutions. If you're someone who's ever wavered over the legal safety of your crypto holdings, this is a refreshing development. This clarity also carries profound implications for taxation, financial reporting, and even regulatory oversight. With a statutory foundation, lawmakers and regulators can now establish more precise rules that impact tax liabilities and investment disclosures. That means fewer surprises when it comes to the taxman and a smoother process. If you ever need to secure financing using digital assets as collateral, the benefits ripple out, affecting not only individual investors, but also financial institutions and advisors who work with digital asset portfolios. Let's take a closer look at one key benefit: asset protection and inheritance. The Act spells out clear rights for digital asset holders in the context of estate planning. In the past, if a family member passed away holding significant digital investments, legal battles could erupt over a murky asset classification. Now, these assets are explicitly recognized, making it easier to draft wills, trust agreements, and estate transfers. Imagine the relief of knowing your digital legacy carries the weight and certainty of physical property. No more grey areas or lengthy court disputes. But as with any new legal framework, there are debates and nuances. Some critics argue that the Act might still leave room for interpretation in nuanced cases, or that rapid technological evolution could outpace the law, and that's a fair point. While the Act lays a solid foundation today, it also mandates that regulators and legislators stay agile. Digital assets evolve at breakneck speed, and occasional updates may be needed to bridge gaps or clarify emerging use cases. However, The remarkable progress made by the Act shouldn't be underestimated. It's an essential step in marrying traditional law with the digital future. Now, let's address a common myth. Many people assume that the legal recognition of digital assets magically makes investing in crypto risk-free. Nothing could be further from the truth. Once you peel back the layers, you see that while the statutory framework enhances legal protection and clarity, the inherent market volatility of digital assets hasn't vaporized. Think of it like a state-of-the-art safety harness in rock climbing. You're better protected, but you still need to know your route and watch your step. So, before diving into any investment, make sure you understand the volatility factor and adopt a balanced strategy. An important aspect of the Act is its pioneering role in setting a global precedent. The UK's approach to digital assets is likely to influence discussions in other jurisdictions. If you're wondering, should I be comparing international legal frameworks to tailor my investment decisions? The answer is a resounding yes. As digital assets continue their explosive growth, every country will grapple with how best to regulate and integrate them into their existing legal systems. By watching how the UK navigates these waters, you gain valuable insights that can inform both domestic and cross-border investment decisions. Let's now explore the broader historical and economic context of this shift. Traditionally, property law has been rooted in centuries-old principles dealing with physical assets like land and tangible goods. For a long time, digital objects occupied a legal twilight, recognized through court decisions or policy guidelines, but never cemented by statute. The leap from court interpretation to full statutory recognition mirrors, in many ways, the journey that smartphones took from being a niche gadget into an essential tool in our lives. Early adopters are often left with the bumps and bruises of uncertainty. Now, thanks to the Act, future investors can step into a more predictable and secure environment. This excitement is palpable among legal experts, financial advisors, and importantly, everyday investors who now have an extra layer of protection when dealing with digital assets. For instance, if you're a fintech entrepreneur or someone bridging traditional finance with emerging tech, this law is a signal that you'll have clearer guidelines and enhanced confidence in your business dealings. It's not just about protecting investments, it's about fostering innovation by providing a regulatory framework that encourages growth while curbing potential risks. What does this mean practically for you? One concrete takeaway is to reevaluate your digital asset holdings. Review your portfolio with this new legal landscape in mind. Are your digital assets backed by robust security measures? Do you have clear records that align with legal requirements in case you need to navigate an estate or resolve a dispute? Now is a perfect time to consult with legal and financial advisors who understand both traditional and digital asset frameworks. Proactive steps like these can safeguard your wealth in an increasingly digital world. Another actionable insight revolves around tax planning. With clarified asset classifications, tax authorities have a firmer basis for how they treat gains, losses, and transactions involving digital property. For many investors, this means new record-keeping requirements and possibly even shifts in how capital gains are calculated. In this evolving environment, it's vital to keep abreast of the latest tax guidance and update your financial management strategies accordingly. A conversation with a tax professional could uncover opportunities to optimize your tax position in light of these changes. Now, let's touch upon the impact on financial institutions and market infrastructure. Banks, insurers, and investment firms are all watching closely. The new legal clarity means they can now offer products and services that incorporate digital assets with greater confidence. Think of it like societal acceptance of a new language. Once regulators and banks speak the same concise dialect, transactions become smoother and more secure. For example, collateral lending using crypto assets could become more mainstream, giving you access to liquidity options that were previously off the table. I also want to highlight a contrarian view that's been making rounds. Some argue that digital assets have been overhyped and that regulatory clarity might eventually expose them as marginal in comparison to traditional economic assets. However, this perspective overlooks the fundamental shift in how value is stored and transacted in the digital era. Yes, volatility is a fact of life, but so is the evolution of technology transforming every facet of our world. Digital assets aren't just passing fads. They represent a natural progression of financial innovation. As a UK professional, appreciating both the risks and opportunities is crucial. Visually, imagine your portfolio as a modern skyscraper. Traditional assets lay the foundation, solid, dependable, and familiar. Digital assets are like the glass panels that add both beauty and risk. They reflect the shifting light of market dynamics and new technologies. A clear legal framework, as established by this Act, acts as the steel reinforcement, ensuring that the dynamic display won't crumble under pressure. It's an infrastructure upgrade for the digital economy. So, where do we go from here? The property, digital assets, etc. Act 2025 isn't just about recognizing crypto and NFTs on paper. It's about embracing a future where digital assets are integral to everyday financial decisions. For you, this means being prepared, staying informed, and being proactive about adapting your financial strategies to a dynamic legal environment. As we draw towards today's resolution, reflect on the lessons this legislative milestone offers. Digital assets may have risen out of the shadows of uncertainty only recently, but their journey from niche collectibles to mainstream wealth components is accelerating. Like any thriving ecosystem, the balance between innovation and regulation is key. The legal clarity bestowed by the Act is an invitation to reimagine your financial portfolio, one that isn't weighed down by ambiguity but empowered by clear, thoughtful rules. Picture yourself at the forefront of this digital revolution. With each new digital asset purchase or sell, you're not merely participating in market speculation. You're engaging with a broader narrative about how property, wealth, and technology intersect. It's a story of evolution, innovation, and the ever-changing quest for security in an unpredictable world. And if you're smart about your investments, you'll let these changes guide, not scare, your decision making, ensuring that you're always a step ahead in the wealth game. Before we wrap up, consider this. What steps will you take today to fortify your digital portfolio? Will you schedule a meeting with a financial advisor who understands both the traditional and digital markets? Could updating your estate plan now protect your future generations in this digital era? These questions are not only relevant, they're imperative. The law is clear, the future is bright, and the opportunity to reassess and re-engineer your financial strategy is right at your doorstep.